Hey there, job hunters and corporate employees. You may be facing age discrimination in the workplace currently or may have encountered it in the past. You might also be looking for a way to prevent this from happening to you. Whichever way, you're probably here to learn how to fight this injustice properly. Don't worry, we've got you covered. In the United States of America, age discrimination and ageism is considered to be a very serious subject matter. Official laws have been passed to ensure that everyone who seeks a job or is currently employed is duly protected and not discriminated against. If you're serious about pursuing a case, you will definitely need the services of a professional practicing lawyer. We're sure you've heard of the term racism at some point or the other, but have you ever heard of the term ageism? Here is what the term means. According to the U.S. Equal Employment Opportunity Commission (EEOC), age discrimination refers to the treatment of an employee or applicant differently or less favorably because of their age. Like we mentioned earlier, there's an official federal law in the USA called the Discrimination in Employment Act. This act is designed to protect individuals over the age of 40 under a wide range of employment umbrella, including job assignments, hiring, firing, layoffs, remuneration, and welfare. Under the Discrimination in Employment Act, employers are not allowed to discriminate against workers whose ages begin from 40 and above simply because of their age. The law is applicable to private employers who have at least 20 employees on their payroll. Ageism in the workplace can also mean that you stand a chance of getting laid off or pressured into early retirement as a result of your age. This is in addition to the most common problem of not being employed as a result of your age. If you also get unfair and negative treatment because of how old you are, this also applies as age discrimination in the workplace. How are you so sure that a job you were not offered after you followed the application process as a result of age discrimination and not in fact because you were not adequately qualified? If you're already employed, let's assume a much younger colleague got promoted to a position you were also vying for. Would you be successfully able to prove your company's decision was based on age discrimination and not a genuine and valid reason? These are the questions makes proving age discrimination in the workplace quite a Herculean task. How to prove age discrimination in the workplace? First of all, we would advise you to also check if the state you reside in offers any additional age discrimination laws with tougher protection. For example, if you reside in New York City, the city's age discrimination laws cover and protect all employees who are 18 years old and above. Also, note that the criteria for ascertaining age discrimination will vary based on your location. However, no matter which jurisdiction you are, if you can provide solid evidence to support your age discrimination claim, then you have a much stronger claim. What kind of evidence can support your claim? We suggest the following. First, making notes about instances of age discrimination you've experienced as soon as it occurs. Include details like what was said, by whom, witnesses present, and so on. We also suggest you write down a list of witnesses who were present when the incident occurred. This will greatly help your lawyer as well. Another reliable option is to make a formal report by writing either to your Human Resources Department or to your immediate boss. We advise you to check your official company employee handbook when writing this report to ensure you follow the company's official policy. The good thing about following this course of action first is that you will be enabling your company a fair chance to weigh in on the discrimination report and hopefully rectify the situation without any need of getting a lawyer involved. Writing a formal report to your company first about the matter also gives you a much stronger case if or when it gets to court, should it get to that stage. If you're unsure about how to write the report, you could also get a lawyer specialized in age discrimination to advise you on how to do so. Another way to defend yourself is by ensuring you make enough copies of all your performance evaluation records and all other official company documents which can substantiate your claim that you do indeed do a good job in your office. Ensure that all complaints pertaining to age discrimination in the workplace experienced by you have been put down into writing. Make sure you also keep adequate photocopies of these records in your home as well and not just in the office. It's for your own protection. Like we mentioned earlier, proving age discrimination in the workplace can be a bit tricky and hard. This is because in most cases, hiring managers may not be so direct and expressly say, "We're sorry, however, we don't hire candidates over the age of 50. Also, language can easily be coded. For example, if you're facing a situation where you believe your boss is using pressure tactics to get you to retire, it may be subtle suggestions and hints, body language, euphemisms, and so on. You may also experience outright workplace age-related harassments, but unfortunately, you may not have any witnesses to corroborate your encounter. Don't worry, age discrimination lawyers are highly skilled and trained to handle special cases like these, and reaching out to hire one is the first step in ensuring you make a very solid case against age discrimination in the workplace. Methods of proving age discrimination in the workplace. Under the Age Discrimination in Employment Act, age discrimination can be confirmed under two theories. One of these theories is known as the disparate impact theory, while the other is referred to as the disparate treatment theory. Depending on the circumstances at hand, one of these two theories can be enforced in a variety of legal cases. The disparate treatment theory. Under this theory, an employee is required to prove that the discrimination they suffered on the basis of age is intentional. The employee first makes what is referred to as a prima facie case. That is, a preliminary demonstration of age discrimination by establishing the following. 1. The employee is competent for their job position. 2. The employee, at the time the discrimination was carried out, was 40 years old or above. 3. The employee experienced a negative employment action such as a demotion, getting fired, and/or changes to the conditions, terms as well as privileges of employment. 4. The opposing employment action arose under facts which gave rise to an insinuation of discrimination. These facts may include factors that an employee was fired and substituted for a much younger employee. In order to win a claim of disparate treatment discrimination, the worker has to prove that age was indeed the legal reason for the said discrimination. In other words, the worker has to demonstrate that if it had not been for their age, an adverse action would not have been carried out against them. Once the prima facie case has been recognized, the employer will need to state a legitimate, non-discriminatory reason for the act suspected to be biased. All the employer needs to do is to provide enough evidence that the reason is in fact not biased in order for a jury to decide the case. If the employer does this, the worker, in order to succeed, must demonstrate that the reason given by the employer is false and the discrimination is the real reason. If the worker can demonstrate that their employer's stated motive is false and just an excuse for discrimination, then the worker will win. Sadly, most employers are sophisticated in matters like this and usually have a number of defenses to employee claims of employment discrimination. The disparate impact theory. Under this theory, it is not necessary that intentional discrimination is proven. Instead, the employee filing the claim needs to establish disparate impact age discrimination by proving that their employer has work practices that have an excessively negative effect on older employees. To succeed on a disparate impact theory claim of discrimination, the complainant has to ascertain a specific employment practice that has a disparate effect on employees who are aged 40 and above. This practice has to be unbiased on its face. It also has to have the potential to injure older employees more than employees who are younger, and it must also apply to specific groups of employees. Examples of specific employment practices include measures that are enforced and used to recognize individuals who need to be fired in a reduction in force. This is also known as a large layoff or a RIF. Another example of a specific employment practice is worker screening tests. Note that an employer company can defend this claim by demonstrating that the action being challenged is based on other reasonable factors minus age. These reasonable factors include: the employment practice aligns with the necessity of the business. The employment practice is interrelated with efficient and safe job performance. Did you find this video helpful? Kindly subscribe to our channel and hit the notification bell so that you'll know when we post a new video. Also, drop your comment so we'll know your thought. Don't forget to check the description below for more details. Visit our website, officema.com for more office content like this. Thank you for your time.